Hello, everyone. Good morning to all participants of the Paris Arbitration Week. My name is Marina Zenkova. I am an associate at White & Case in Moscow and a member of the committee of YSIAC. We will start this last day of this year's Arbitration Week with a discussion of the recent developments and key arbitration trends in Asia. It is not a secret that use of arbitration continues to rise in Asia. Asian arbitration seats and institutions are getting more and more popular among the arbitration practitioners all over the world. So it's definitely worth looking at the arbitration developments in Asia more closely to follow what's happening in different parts of it right now. This year, our events agenda includes 4 Asian jurisdictions: Singapore, Indonesia, Japan, and Thailand. And we have a beautiful panel of arbitration experts whom I will now introduce. Peter Harris is counsel at Clifford Chance in Tokyo. Winatiya Ratna is a senior associate at Somali Praja and Tahir in Jakarta. Jetsarit Sahasarungsi is a senior associate at Veeravon Shinawat and Partners in Bangkok. And Nantini Vijayakumar is a senior associate at TSMP Law Corporation in Singapore. Now, before I give the floor to the first speaker, if you have questions to our panelists, please type them in the Q&A field that you can see in the bottom of your screens. I will do my best to put their questions to the panelists after their presentations. I must say, however, that we may not have sufficient time to answer all questions if there are many, so I apologize in advance for that. To start our conversation today, I will ask our speakers to give a brief general overview of their respective jurisdictions. I've never been to Japan, and to me, it's probably one of the most mysterious and intriguing countries, so I want to start with Japan. Peter, what is it like being an arbitration lawyer in Japan?
Well, thanks very much, Marina, and good morning, good afternoon to everyone. It's a pleasure to be here on this webinar talking about arbitration in Japan. I'm happy to try and demystify some of that if I can, and it's a great pleasure to be at an event that's brought to us by YSIAC and Paris Arbitration Week. So arbitration in Japan, I think it's fair to say, Japan's not always been known as an arbitration-friendly or popular jurisdiction for arbitration. Even though Japan was a relatively early signatory to the New York Convention in 1961, it didn't really take off here for quite a while. And one big reason for that was that Japan actually didn't implement legislation until 2003. So it's really only in the last 2 decades that there's been a big growth in arbitration in Japan and Japanese parties using arbitration. And even that has been relatively slow to start with. But just before we sort of talk about where we are now, I thought it'd be helpful if we sort of went back in time 20 years and thought about where is Japan then. So in 2001, Japan had signed the New York Convention but hadn't implemented its arbitration law, which is now in force based on the model law. And one commentator at the time wrote a book, and he wrote, "Despite the Bar Association's efforts to promote arbitration, utility rates of arbitration have not increased dramatically, since not only the legal framework, but also human resources are too poor to gain people's confidence in arbitration." So an extremely downbeat yet informed view of the market 20 years ago. I think if Mr. Sato could look at the situation today, he would be pleasantly surprised that actually I can't go to the coffee stand below my building without bumping into another arbitration lawyer, and Japanese parties are globally arbitrating to resolve their business disputes, and the Japanese government has been supporting that in a number of ways. One of the things that the government has done is to support the Japan Commercial Arbitration Association, which is the local center here in Tokyo. I think it's fair to say that although it got quite busy in the initial decade of the millennium, it then sort of plateaued a bit, but it's recently been revamped, and it's got some extremely talented people working for it, and it's got some top quality arbitration rules, including an interesting menu of 3 sets of rules that parties can choose. They can choose the classic UNCITRAL rules, or they can choose the Japan Commercial Arbitration Center rules, which have some novel features, so no dissenting opinions allowed, things like that. That's quite unusual. And they've also got a sort of civil law category on the menu of interactive arbitration rules for perhaps more civil law or modern-minded parties. And they include things like an article that says that the tribunal itself should, early on in the proceedings, establish the parties' positions and what the issues are in the case. I wonder if that's something all tribunals could perhaps benefit from doing. So it's got some interesting features. It also is quite advanced in terms of its technology. It's got provisions in there for virtual hearings, should the parties wish to do that, or the tribunal want to push that upon the parties. So quite good functional set of rules, very good panel of arbitrators, and a well-run centre. And to support that, more recently, the government has invested in the Japan International Dispute Resolution Centre, the JIDRC, which is a state-of-the-art facility dedicated to arbitration. And in fact, it was occupied the whole of this summer hosting the Court of Arbitration for Sport, who were in Tokyo for the Olympics. So that was a great workout for the JIDRC, which is a really good piece of infrastructure to have in the Japanese arbitration landscape. In terms of the sort of more hard law factors, Japan's got a good record of enforcing arbitral awards. There have been, I think, in the past some unusual court decisions regarding challenges to arbitrators, but on the whole, it's fair to say, I think, that the judiciary is generally pro-arbitration, understands arbitration, and will provide strong support for arbitrations that are seated in Japan. And that is only going to improve with current proposed amendments to the arbitration laws. They're just going through at the minute. They've been through one round of comments. But I think the 3 features of the rules I'd highlight today would be that, one, if you're going to enforce your award in Japan, currently you do have to translate it into Japanese. The new law amendment should dispense with that requirement, so it will be easier to enforce without translation. It should make the position with regard to interim measures clearer, and is likely to make interim measures ordered by arbitral tribunals enforceable in Japan. And finally, there's a bit of a push for a process for the enforcement of mediation decisions and awards, which would be consistent with the Singapore Convention, but Japan obviously hasn't signed that yet. But mediation in Japan is also a growing form of dispute resolution, and we might talk about that a little later. So I think that's probably the summary I can give. I hope that's been of some use, Marina and everyone, and I'll stop there and would like to hear more about another jurisdiction.
Thank you very much for this overview, Peter. To save the time, I will keep my questions until after all presentations. I think I'll just remind to the audience that you can send your questions to the speakers using the Q&A option button in the bottom of the screens. So I will move to the next jurisdiction, and I give the floor to Jet Sarid, who will talk about Thailand.
Hi all, it's my pleasure again to talk with you guys and the YSIAC event joined with Paris Arbitration Week. Thailand is also very similar to some extent to Japan. We are one of the first Asian countries who actually rushed to join the New York Convention in 1959, right after the signature of the convention. So, but we had law, internal law, only from 1988, 1989. So it's quite some time until we make up our mind to actually do something about it. As you may know, Thailand is a civil jurisdiction, so we have the same concept, the same principle. We tend to use court law. That's why we have to implement the New York Convention by, enact another law or act called Thai Arbitration Act, which has been used for some time and has been revamped, repealed and revamped in 2002. So since then, it has been very minor changes to the act, which is modeled after arbitral model law. So you probably expect the same features as in other countries. For example, like courts have adopting non-interventionist approach and supporting or trying to enforce the arbitration awards as much as it allows. So I think pretty common to all civil law jurisdictions. Thailand also, you don't use US style discovery. You do not have any prohibition for witness prep. So we pretty flexible about everything. What has been intriguing features of Thai arbitration recently was that the change recently in a couple of years, amendment to the Thai Arbitration Act, which expressly allow foreign arbitrators and foreign counsel to come to Thailand to do arbitration. And they also implement a regime called Smart Visa, which allows Thai foreign arbitrators and foreign counsel to come to Thailand and get visa upon arrival. So that's better approach and trying to make sure that the standard here in Thailand is in line with international practice. And to give you a general background in terms of institutions, Thailand has two arbitration institutions. One is a TAI, which is quite a long-standing one since 90s. And then we have another one from the Ministry of Justice. Sorry, the TAI, the Thai Arbitration Institute, is the one administered by the Judiciary. Whereas the one THAC, the new one, 2015, probably you guys have heard about it, has been very active in arbitration in Thailand and elsewhere, convening various interesting arbitrations work, has just been instituted and found in 2015. So we have two sets of institutes. Their competition is pretty healthy. So they both have different targets. One, probably targets more international approach or international clients, whereas the other one, target more like domestic clients. Anyway, in Thailand, Thai courts, when we have Thai Arbitration Act, we adopt non-interventionist approach, as I mentioned, and they have a very good track record of enforcing awards, especially commercial awards, not investment awards. Because Thailand only participate in investment treaties, in investment arbitration is only for two. So we pretty new in the field of investment arbitration, but we have a very good track record for commercial arbitration and enforcement. And we also see that the courts tend to interpret the exception of public policy very narrowly recently. So we can see that it is going towards the more friendly approach to arbitration. In terms of the roles of the court, it's similar to all jurisdictions which adopted the arbitral model law. However, I would like to stress that Thai court has a very good track record of issuing an order striking out cases due to existence of arbitration agreement. So when you have arbitration agreements, Thai courts tend to respect that and striking out the case immediately when it is found. And the exception is very, very high threshold of proof. And it's not, however, in terms of the bad side of things, we talk about good things a lot. The only drawbacks is that Thai courts tend not to issue interim measures in assistance to arbitration proceedings. That's not the case for the court case. sometimes it's easier to get interim measures for court cases. However, because now I think it's getting better because Thai courts tends to recognize more and more arbitration awards and developing their grounds and their resources on arbitration internally and their trainings internally. So I think we can see a better interim measures issued by courts very soon, we hope. Another thing that I would like to note that Thailand doesn't have any no differentiation between Thai domestic arbitration and international arbitration. So we treat them equally, and we don't have a separate set of rules or law for those two separate set of regimes. Unlike some countries. Another thing that I am sentiment, I have a same sentiment as Peter, is that Thailand is also we use Thai language for Thai proceedings, so we have to interpret everything. We have to use interpreter and we have to use a translator for everything as well. We don't see any changes soon, but I hope we can get see Japan as a model, and we can model on Japan and then trying to use a more international friendly approach to international arbitration. Yes, and probably that's all that I can give. Just give a big floor, but I would love to speak to and answer any questions that you may have on Thai jurisdiction. Thank you.
Thank you, Jethrit. Just to pick up quickly on something that you said about Thailand easing the conditions for the international and foreign lawyers who can now act in arbitration. I think that it's kind of a general tendency in the Asian jurisdictions right now. I think that's the same is happening in Japan, if I'm correct.
Yeah, it's much easier now to come in and do arbitration as a foreign lawyer.
So just wanted to highlight this as a general maybe tendency in many Asian jurisdictions. So now we'll talk about Indonesia. Winatia, please tell us what an arbitration practitioner should know about Indonesia.
Hi, thank you, Marina. Good afternoon, everyone, and good morning as well. Indonesia is a little bit different. Although we are a party to the New York Convention, which means that international arbitration awards are recognized and enforceable in Indonesia. However, our arbitration law is not based on the UNCITRAL model law. Our arbitration law, we call it law number 30 of 1999, has never been amended, and it's primarily based on the principles from the old Dutch law. But in the arbitration law, it incorporates some provisions of the New York Convention. Our arbitration law allows parties to opt for institutional or ad hoc arbitrations, including to choose domestic institutional arbitrations or international institutions or ad hoc. Speaking about domestic arbitration, institutional domestic arbitration, I think it is important to highlight that the most prominent arbitration institution in Indonesia is called BANI. However, now there are two BANI. We call it the former or original BANI and then the new BANI, which is sovereign BANI. The two have been disputing, and it's although the civil dispute has already been reached to Supreme Court. However, the Supreme Court did not review the deed of establishment of the new BANI. So nevertheless, the new BANI still exists. And then now we recommend parties, like when they make their dispute resolutions provisions in the agreement, they have to identify which BANI. So by saying the address of the BANI office, you're going to opt for the original old BANI or the new BANI. Speaking about arbitration itself, I think Indonesia is becoming more and more friendlier with international arbitrations. The reason why I say this is because there is a strong track records by the courts and then the Supreme Courts that they enforce international arbitration awards. And like Thailand, when they see like the parties have agreement to settle their dispute in arbitrations, they will strike out any application to review the case before the court. As for foreign counsel to act in arbitration proceedings in Indonesia, generally they may, but they have to be assisted by an Indonesian qualified certified lawyer. We do not distinguish between solicitors and barristers. We only have advocate, and in order to be an advocate, you have to go through like some tests and you got certifications. So as a general principles, only Indonesian lawyers can appear before the court. I think the same understanding also applies for institutional domestic arbitrations. However, if you opt for ad hoc and then the matters or the dispute involves some Indonesian law matters, it is highly advisable that you have a licensed Indonesian lawyers to assist you and to appear together with the foreign counsels in the arbitration proceedings. Court interventions is also very limited. It is very limited to the appointment and replacement of arbitrators, and in theory, at least for the enforcement of interim relief. Our arbitration law allows arbitrators to grant provisional or any interlocutory relief. However, the law does not expressly provide the mechanism for enforcement of such award if a party refused to do so voluntarily. Any interim reliefs issued in an international arbitration proceedings will be deemed as an international arbitration award, and it has to go through the same process for enforcement of international arbitration award. By saying that, our law differentiate between domestic arbitration award and international arbitration award. With the domestic arbitration award, you have a 30-day period to register your award after the issuance of such award. And for international arbitration award, there is no specific deadline to register your award. The law also provides reasons for annulment or set aside of domestic arbitration award. There is a recent constitutional court case in which strengthening that the reasons provided in our arbitration law for setting aside an award only applies to the domestic award and not for international arbitration award. Any setting aside of international arbitration award is subject to the court of the seat. So Indonesia only has jurisdiction to set aside award, which arbitration is seated in Indonesia. In terms of enforcing international arbitration award, there is one criteria that is of importance, which is the award does not contravene public order or public policy. This one is a little bit could be somewhat difficult because there is no strict definition or guidelines on the definitions of public policy or public order. The reason cases that we have in Indonesia is relating to the language law. So Indonesia promulgated a language law which requires parties that an agreement that is made with Indonesian individual, Indonesian government institution, or Indonesian companies. The agreement must also have a Bahasa Indonesia. The law does not expressly state that the governing language must be Bahasa Indonesia, but it has to be accompanied by Bahasa Indonesia. The law does not provide any penalties in the absence of Bahasa Indonesia version. However, this has been used as a ground for the parties that is lost in their arbitration case to file a claim before the relevant civil court to make the arbitration award unenforceable, because that in the absence of Indonesian language in their arbitration agreement or in the agreement as a general means that that agreement is not in accordance with the principles for a valid agreement under our civil code, and thus it could be considered as contravening public policy or order. There are several Supreme Court cases which is in favor of that argument. However, Indonesia is based on civil law, so we do not recognize stare decisis in the sense that the Supreme Court decisions are not binding, but only for guidelines. And in terms of the language issues, there are other court decisions which is saying, well, the party has a freedom of contract. The party may choose just to have one language, and therefore it is not immediately null and void such agreement. So it's interesting, and it's still ongoing, but in general basis, we always tell our clients, don't forget to make a translation, a Bahasa Indonesia translation, just to make sure that when you have a dispute, this won't come up as an issue for enforcement. Thank you, and that's the highlight from the Indonesian jurisdictions.
Thank you very much, Winotia. Last but not least, let's turn to Singapore. Now I have the following question to Nantini. We know that according to this year's White Case and Queen Mary University survey, Singapore was ranked as one of the 2 most preferred arbitration seats in the world. So what's your opinion? What are the reasons for Singapore's increasing popularity over the last few years? If you can start with briefly answering that and then go ahead with your presentation, that would be great.
Thanks, Marina. Good afternoon, everyone. Thanks for joining today's webinar. To address Marina's question, I think Singapore is getting more and more popular because we are known for being a pro-arbitration jurisdiction. So you can see that from both the judicial decisions that have come out in recent years, as well as the legislative amendments that have been made to our International Arbitration Act. So we are always amending it to ensure that we keep up with the changing landscape as well as the new complexities that arise in arbitration. So I think in the last 8 years, we have made 4 amendments to the International Arbitration Act, the most recent one in December 2020. And there are also additional amendments being considered. In 2017, quite a major amendment was made to our Civil Law Act as well to allow third-party funding in international arbitration as well as related court disputes and mediation. Just 2 months ago, it was expanded to include domestic arbitrations as well. So that's quite a big step for us. That goes into actually my presentation for today, which where I wanted to discuss the December 2020 amendments to the International Arbitration Act. There were 2 key amendments. The first one was to provide for a default mode of appointment for arbitrators in multi-party disputes. So previously, we didn't provide for a default mode of of appointing arbitrators. And that leads to some difficulties and delays in arbitration proceedings when claimants and respondents cannot agree on appointing one arbitrator to represent the claimant and the respondent. So the IAA was amended to provide for a default mode of appointment. This is, of course, more relevant in situations where parties have not elected to adopt institutional rules that already provide for a default mode of appointment. SIAC rules, for example, already provide for a default mode of appointment in multi-party arbitrations. The second key amendment was to expressly provide that tribunals and the Singapore courts can enforce confidentiality obligations. We all know confidentiality is quite an important aspect of arbitration in general. So an express amendment was made to our International Arbitration Act to clarify that both the tribunal and the courts can enforce confidentiality obligations, whether provided for under institutional rules or if parties expressly agree. I also understand that there are some other amendments that are being considered. They haven't been passed yet. So these were raised in a consultation paper in 2019. One of it is the possibility of appealing a question of law to the Singapore High Court. The second would be to provide the court power to address costs in the event a party is successful in setting aside an arbitral award. So at this point, when a party sets aside an arbitral award, essentially cost orders that form part of the arbitral award are also set aside. So there's kind of a lacuna there, and we are also considering an amendment to address that issue. So obviously these amendments are, I think, not very common in ancestral model law jurisdictions, which is probably why we're taking more than 2 years to consider whether to introduce this amendment. So hopefully when we come back next year, I'll have an update on that front. So that's all for my introduction. Marina, I'll hand it back to you.
Thank you, Nantini. So now that we've had an overview of the key features of each jurisdiction, I want to ask the panelists to tell us about some interesting recent developments and hot current topics in their respective jurisdictions. And we will start again with Japan. So Peter, the floor is yours.
Thank you, Marina. I thought in terms of hot topics and latest developments, I'd limit myself to 3. Firstly, third-party funding. Secondly, the impact of investor-state arbitration and arbitration practice on Japan and the Japanese arbitration market. And finally, talk a bit about technology. So funding, there are different views on legality, but I think, and I welcome any comments on the chat to disagree, but I think there is a consensus that at least there is no express legal prohibition on arbitration funding in Japan. There are some questions around the involvement of non-lawyers in legal proceedings, which I think is where the grey area comes, but I think it's fair to say most arbitration practitioners and funders take a fairly robust view, and at least one funder has set up in Japan and is reportedly funding a case, and it looks, at least to me, that the market for arbitration funding in Japan will grow. I think ultimately it may need an amendment to the law to expressly provide for it, or a case to show that it's okay. But certainly it's something that Japanese parties have an interest in. Some parties use it abroad, and I think if it takes off in Japan, it's likely that because of the way some of the companies here are structured with their own balance sheets, it could be something that's taken up quite rapidly and with quite wide-ranging popularity, particularly to de-risk the cost of arbitration proceedings, which is front of mind for a lot of Japanese in-house legal and business departments. So I think that's one to watch for Japan, arbitration funding. I also think the impact of investment treaty arbitration practice in Japan is very much worth mentioning. So while Europe arguably is moving away from including investor-state arbitration clauses in its treaties, Asia is continuing to use them and continuing to negotiate those benefits on behalf of their investors who are going overseas. And Japan is an example of this, where in the period between 2010 and 2020, Japan signed up to more than 20 BITs, investment treaties with arbitration clauses. And the government is promoting those treaties to Japanese corporates as a means of de-risking their overseas investments, which Japan obviously needs. It needs to go shopping for energy and resources elsewhere, but it's also globally connected to the marketplace for Japanese companies, and so to support Japanese companies doing business abroad, the government's gone out and negotiated a number of treaties with other governments that essentially give those investors rights in the event that the foreign government does something like expropriate, nationalize, or otherwise poorly treat their investments. And Japanese companies are starting to use them. So we had over the last few years at least 3 treaty claims against Spain that have been launched under the Energy Charter Treaty by Japanese parties. Nissan has launched a case against India, and further back in time, the Saluga Czech Republic case was actually subsidiary of Nomura. So Japanese companies are no stranger now to using investment arbitration. I think that practice and the use of arbitration and understanding of the procedure has percolated through corporate Japan. So there's lawyers who are familiar with it, there are businesses who are more familiar with it, and that crosses over into commercial arbitration because they're just familiar with the process and they get what it means. And you only have to look at like the Colombia-Japan relatively recently negotiated investment treaty, which contains some extremely sophisticated provisions around tribunal appointed experts and things like that, to know that, well, somebody's been doing some arbitration here and understands what it is and how it works. I could go on about that a long time. I've written quite a lot in a paper that was actually published by the SIAC's Asian International Arbitration Journal in May this year, called Growing New Wings. So if you want more on that, that's in that article. I'll just end very briefly on technology. It would be wrong, I think, to talk about Japan and many things in the world without mentioning technology, but there's two strands, I think. One is technology-related disputes, technology-related arbitration. Japan potentially is a very good home for tech companies because there is a lot of tech know-how here, and there's some precedent for the Japan Patent Office doing IP arbitrations, and I think it's something that Japan could develop as a particular sector specialism for arbitration and mediation potentially. And there's a lot of lawyers who work in that sector here, so that might be something to watch again. As well as, on the flip side, there is arbitration-related technology, which is a totally separate thing, but the use of technology in cases, I mean, we've all experienced that over the last couple of years with the pandemic, the growing use of technology. Well, Japan is extremely well placed to take advantage of some of the innovations and to lead, in fact, some of the innovations in arbitration technology. And I wouldn't be surprised if there are things coming up from the YSIAC and other groups in Japan which really move the needle in terms of what parties can expect from the centres and the way cases are run and managed using technology, including in providing some more transparency to users of arbitration who currently aren't sure what centres actually do, or have to ask their lawyers to see documents from a case. So I think that's another watch this space area for Japan. Thanks.
Thank you, Peter. We'll move to Thailand. I just wanted to highlight that we have a couple of questions about third-party funding and whether contingency fees are allowed in arbitration-related cases in your jurisdiction. So Peter covered this to some extent in his presentation. Just read if you want to touch upon this in your presentation as well. And just anything else that you wanted to cover.
Sure, thank you. I think, just a brief note on third-party funding. It's very fortunate that we, Thailand, as our firm, had joint host an event with SIAC 2 years ago before COVID about third-party funding in Thailand. And unfortunately, in Thailand, is still illegal. It's not only inappropriate, illegal. It's fortunate, very unfortunate. This is because we still adopt the same policy, similar ones to the English code, which is a champati and maintenance. But we picture it or trying to present it in the way of public policy. So any structure or arrangement in relation to third-party funding would be in a high likely be qualified as contrary to public policy or good morals, and that leads to void of agreements. Sorry, however, for contingency fee arrangement, because there is a slight difference in that and from Thai law perspective, so it may be possible, but you probably have to consult your lawyers pretty closely on how to structure it in a way that it would not lead to, illegal arrangements between lawyers and between private parties. I think that's probably cover it. If there is no other questions, I will probably go ahead with my prepare topics on hot topics and recent developments in Thailand. I would categorize the recent developments into two ways. One is the liberalization. As I mentioned, we welcome more foreign counsel, foreign arbitrators. We have revamped our visa regime to give smart visas to foreign lawyers. Before that, we even have tactics of trying to catch lawyer or try to catch foreign lawyer at the airport and try to claim them for illegal work permits in Thailand. But that's go away already. So because of this revamp, so there is no tactic like that anymore in Thailand. And we also have a substantial development in terms of marketing by arbitral institutions in Thailand, THAC and TI, now promoting more and more internationally. And they also include a lot of foreign arbitrators and counsels in the roster of arbitrators in their respective institutions. So if any of you would like to come to Thailand more often, we are very welcome for you to register. However, it's not limited to that. We can select any other foreign arbitrators or foreign counsel outside the list. No worries. For another topic of recent development is inclusivity, and that's overlapped with what Peter has just mentioned about technology. So we provide more access to justice or access to arbitration by using electronic means. We have e-arbitration in these two institutions in Thailand, and we also there is no prohibition of using electronic means for dispute resolution in Thailand. Even Thai courts now is adopting electronic means or electronic hearing. So I think we can see a very positive ways going forward in terms of electronic hearing, electronic proceedings. And that's also because of the COVID. It has now been much more important and more vigilant for everyone, and it is encouraging for everyone to use electronic means and exchange of emails. Apart from that, we also see a very new developments, because in Thailand it's pretty hard to amend laws nowadays. It has been in the past as well because of our political climate. But that's why when we looked at our trends, we usually look at the rules, because it reflects what arbitrators or leading practitioner thinks about the developments in the future. So they develop rules first before going to amend the laws. So it probably other way around for other countries. For these new features in our rules, and which we can expect for the law amendment as well, is the arbitration class actions. So we allow class action for arbitration proceedings. We have small claim arbitrations for open up for small enterprises, small or medium enterprises, or SME, to go for small and quick expedite procedures in SIAC rules. And also we also have the changes in relation to more influence. Now arbitrators or practitioners in Thailand tends to recognize more guidelines and soft laws, which has been agreed around the world. For example, the IVA guides, IVA guidelines or regulations, that's our new development as well. So people are opening up their heart to make sure that the Thai practice is in line with international practice. Apart from that, I would like to highlight some key topics which has been hotly discussed among practitioners here in Thailand. One of the things is that, that's probably what she has mentioned in her presentation, that previously Thai courts tend to set aside foreign awards, which is contrary to normal sense of normal arbitration practitioner, because set aside is only for the arbitration of the seat. But here in Thailand, we set aside those foreign awards coming to enforce in Thailand, even though it's a application to enforce, not application to set aside. But now the trend has shifted, and the Thai courts has issued a strong judgment recognizing their authority only to enforce foreign awards and not to set aside foreign awards. So that's a welcoming development. Another topic which has been discussed very frequently is about the drafting of arbitration clause in Thailand. I think that's also a very hot topic as well in other jurisdictions in Asia. Given the interpretation of permissive language, not the mandatory language in arbitration clauses, recently also as well in Hong Kong, we see the development that permissive language can also lead to mandatory arbitration obligation, and that Thailand also now we trying to delve with it more deeply by allowing parties to present evidence on the intention of parties if that permissive language give rise to obligation or it's the intention of parties that is a mandatory obligation, that can also be an invalid arbitration clause. And that's probably give rise to a more overall trend of presumption in favor of arbitrality. So now Thailand can enforce arbitration agreements more easily because of this trend. Another development which also impacts arbitration world, but is coming from the court litigation world, is the amendment to the Civil Commercial Code. Now the statutory interest rate is now lowered down to 5%. Beforehand, it was 7.5%. So now the post-award interest from statutory perspective is now lower to 5% and not 7.5% anymore. So if anyone has any contract with Thai parties and aim to enforce award or trying to enforce court judgments or whatever, which has a risk of having to consider the post-award interest, now the interest has been lowered. So this has been taken into account as well. Another thing that I think I should highlight before I go away is that now because Thailand has only 2 investment arbitration cases so far, one involving investment with Germany and one also involving investment from Australia. However, we can see the development that corruption issues has been very active or has been really heavily discussed as an argument to resist protection and also an argument from the government side. That's probably because now Thailand has invited more investment into Thailand. How we expect to see more of Thai private parties having cases with other jurisdiction states that probably come out of Thailand being able to invest outbound and having investment around the world or in different jurisdictions. And I see the time, so I give the floor back to Marina. Thank you.
Thank you, Jetsarit. So let's move directly to Indonesia.
Thank you. Peter and Jet talk about third-party funding. In Indonesia, the Indonesian law does not expressly recognize any third-party funding process. I think whereby the third party may advance funds for legal fees or risk sharing arrangements. But there's no restrictions on how parties obtain financing for litigations because as a general concept, Indonesian law recognizes the principle of freedom of contract. So lawyers and clients may agree to any type of fee arrangements, including a third-party funding process. I would like to also highlight about the legal fees, whether or not in arbitration proceedings, a plaintiff can ask the defendant to cover for their legal fees should the award is in favor of the plaintiff. The answer to that is there's no strict answer. As a general concept, the tribunal costs and expenses incurred in an ad hoc arbitration against the unsuccessful party. If the claim is only partially granted, the arbitration expenses usually will be borne equally by both parties. However, costs and expenses do not include legal fees or disbursements. This is because there was a famous Supreme Court decision which states and has been followed, which states that legal fees cannot be the burden of the other party, both in court cases and in arbitration cases. However, you may keep trying, and because again, like a Supreme Court decision is not binding, it's merely serve as guidelines. But the Bani rules, specific Bani rules, they provide that under extraordinary circumstances where the arbitrator determines that a claim is frivolous or a party has made the arbitration proceedings unnecessarily difficult or complex, legal fees and disbursements may be awarded to the adversely affected party. The other highlights that I want to convey is about the language law. How does that affect in an arbitration proceedings? Can parties still use foreign language in arbitration proceedings? The answer to that, I will give the answer based on my experience. So the tribunal or the single arbitrator usually will look at the arbitration agreement itself. What is the governing language of the arbitration agreement? If the arbitration agreement states that the governing language is Bahasa Indonesia, even though parties to there are some foreign parties into the agreement, then the proceedings will be convened in Bahasa Indonesia. However, if under the arbitration agreement, the governing language is, for example, English language, then the proceedings may be continued using English language. However, when it comes to rendering an award or registering an award, it has to be accompanied by a sworn translations of Bahasa Indonesia. So I think we have to differentiate between, yes, we have a law that requiring parties to make an agreement with Indonesian party to also have the Bahasa Indonesia version. But when it comes to arbitration, one has to come back to the arbitration agreement, check the governing language, and the arbitration tribunal will comply with the parties' agreement. But when it comes to enforcing it, again, like it goes back to the jurisdiction where the award needs to be enforced. It has to follow the local law, and our local law states that it has any arbitration award in a foreign language has to be translated to Bahasa Indonesia.
Thank you, Winatia. So we'll move again to Singapore. I know that it's had a few interests in arbitration related jurisprudence. So if Nantini can cover this, and also feel free to answer the questions that the other speakers and the audience raised.
Thanks, Marina. Okay, so I think I'll start by perhaps making a few more comments on third-party funding, because all my other panelists have covered this as well. So as I mentioned in the introduction, it was introduced in Singapore in 2017, and it's not just limited to international arbitration now. It's also introduced to cover mediations arising out of international arbitrations, as well as court proceedings, related court proceedings, as well as independent stay applications to enforce arbitration agreements. There are some conditions for third-party funders to satisfy before they can fund these kind of disputes in Singapore. So one is that the third-party funder needs to carry out the principal business of funding the dispute resolution proceeding. And the second thing is that minimum paid-up share capital requirements, right, to before you are considered a qualified third-party funder in Singapore. And I understand that right now the amount is 5 million in paid-up share capital, or the equivalent amount in foreign currency. So that's for third-party funding. So I wanted to talk about some of the more recent cases in Singapore, which deals with enforceability of arbitration agreements, as well as costs in setting aside proceedings. So the first case I wanted to briefly touch on is the decision of BNA and BNB, which is a reported decision in 2020. So generally, everyone has the impression that Singapore is very pro-arbitration, which is correct. But there are, of course, limits to upholding an arbitration agreement, and I think BNA illustrates that well. So in BNA, the court actually found that the governing law of an arbitration agreement is PRC law, even though the consequence of that is that the arbitration agreement would be invalid. So in that case, the arbitration agreement provided that the disputes are to be submitted to SIAC, but for arbitration in Shanghai. So under Singapore law, the starting point to determine the law of an arbitration agreement is basically the substantive law of the underlying contract. In that case, the substantive law was PRC law, but the starting point could be displaced if the law of the seat is materially different. So the question before the court was whether arbitration in Shanghai was a reference to Shanghai as the seat of the arbitration. And the court found that that was the case because not only was that the natural meaning of the phrase, but where parties have specified only one geographical location in an arbitration agreement and have expressed a choice for arbitration in that location, then that location is most naturally construed as the party's choice of seat. So on that basis, and the fact that there was no contrary indicia to displace this natural reading, the court found that the seat was Shanghai and the substantive law of the arbitration agreement would be PRC law. So the reason why the arbitration agreement would likely have been invalid is because under PRC law, you can't have a foreign arbitral institution administering a PRC-seated arbitration. So even though that was the consequence, the court still found that it was PRC law that was the governing law of the arbitration agreement. Just one other point I wanted to note about BNA, which I think is useful for all parties to know. As I mentioned earlier, the court found that there was no contrary indicia to displace the natural reading of the phrase arbitration in Shanghai. So it's noteworthy that the respondent in that case actually tried to adduce new evidence before the court on parties' pre-contractual negotiations to show that actually they decided to pick a more neutral seat and not go with Shanghai. But the court actually disallowed the application to adduce new evidence. So this is important to note. Of course, in arbitration, the Singapore Evidence Act wouldn't apply. You generally use things like the IBA rules. But when you come to court, the restrictions on admissibility of evidence in the Singapore Evidence Act would apply. So things like the pro-evidence rule and the exceptions, if parties want to adduce new evidence, they will need to ensure that they satisfy those requirements. So I think that's one important thing that parties should be aware of when coming to, when picking Singapore as a seat. The second decision I briefly wanted to discuss is a 2021 decision of the Singapore Court of Appeal. It's known as CDM and CDP. So there the discussion was in relation to costs awarded to a party who does not successfully set aside an award, costs ordered against a party who does not successfully set aside an award. So this was an interesting discussion because the respondent in that case tried to argue that the approach in Hong Kong should be adopted. So in Hong Kong, the default position is that a party who fails to set aside an award would be ordered to pay costs on an indemnity basis, unless special circumstances are shown. And the rationale for this is that the parties had consensually agreed to submit their disputes to arbitration and accept the award as final and binding. So by trying to set aside an award unsuccessfully, one party has basically gone back on this agreement, which is why the default position in Hong Kong is for indemnity costs to be awarded. So the Singapore Court of Appeal actually declined to follow this reasoning. And basically the position in Singapore is that in order to get indemnity costs, you need to show unreasonable behavior on the part of the party who applied to set aside the award. The reason why the court declined to follow the reasoning adopted in Hong Kong is that the limited avenues to challenge an award are already statutorily provided for, in the same way as a traditional right of appeal in court proceedings. So there's no principled reason to draw a distinction between the two, whether it is setting aside an award or appealing a local high court decision. Yeah, so this is slightly different from how we view things like anti-suit injunctions or stay applications to enforce an arbitration agreement, because in those cases, we are normally talking about indemnity costs. So those are the broad points I wanted to cover, and I'll leave it to Marina to address the Q&A.
Thank you, Nantini. Well, I realize our time is up, but we have some really interesting questions here, so we'll take maybe extra 5 minutes to try to address just a couple briefly. Nantini, we have a question to you about the possibility to recognize an award which has been annulled by the courts of the seat of arbitration in Singapore. Is it at all possible?
So I don't think this issue has been considered yet in Singapore, so I don't have a firm answer for this. But I would think that the courts would generally try to recognize a finding made by another court in relation to whether the award can be set aside. I think they'll try to give due deference to that.
Thank you. Peter, Japanese parties have historically had a tendency to look for settlement of disputes. Do you think that the rise of arbitration has allowed these parties more flexibility and confidentiality in pursuing their disputes?
I think that's an excellent question. It's quite right that there has been a sort of settlement bias in Japanese corporate culture, and so the confidentiality provisions afforded for arbitration are attractive to Japanese parties. It allows them to essentially go through a dispute without everybody knowing about it, which gives them more comfort and more ability, yes, to push their rights. That said, I think there is a bit of a change as well in the culture in terms of Japanese companies going abroad and realizing that actually to get maximum recovery for their investments, particularly in relation to projects, but generally they actually have to pursue their rights. And so the arbitration process allows them not just to deal with something confidentiality as a respondent and then get into a settlement situation, but actually to push a positive claim if they feel that their rights have been trampled on.
Thank you, Peter. And maybe just the one last question for Winatia, related to enforcement of the International Arbitration Award. Does it still have to be with Bahasa Indonesia, or does it just apply to enforcement of the Domestic Arbitration Award?
Thank you. For the enforcement of International Arbitration Award, when you register the award to the Central Jakarta District Court, it has to be accompanied by a sworn translations Bahasa Indonesia if the award is made in foreign language. So yes, it has to be accompanied by Bahasa Indonesia sworn translation.
Thank you. I think our time unfortunately is up, so we'll maybe stop here. So I just want to conclude this webinar by saying thanks to our wonderful speakers who found the time to participate in this event. And thank you to the audience who joined us today and for these interesting questions. Apologies again for not being able to address them all. Thank you to the organizing committee of the Paris Arbitration Week. And last but not least, thank you very much to the extremely professional team of the Singapore International Arbitration Center who made this all happen. So we hope that this webinar was interesting and insightful, and many thanks for joining us today. We hope to see all of you offline sometime soon. Have a great Friday.